We will call this meeting to order. I would ask our media present to slip out there now from the cameras. Thank you very much. I'll just open it first. Well, welcome, colleagues, today to meeting number 53 of the Standing Committee on Public Safety and National Security. Today, under, of course, the orders of the day and pursuant to the order of reference of Monday, February the 23rd, 2015, Bill C-51, an act to enact the Security of Canada Information Sharing Act and the Secure Air Travel Act, to amend the Criminal Code, the Canadian Security Intelligence Service Act, and the Immigration and Refugee Protection Act, and to make related and consequential amendments to other acts. Appearing as witnesses today, we have the Honourable Stephen Blaney, Minister of Public Safety and Emergency Preparedness. We have the Honourable Peter Gordon MacKay, Minister of Justice and Attorney General of Canada. We have from the Department of Justice, William F. Pentney, Deputy Minister of Justice and Deputy Attorney General of Canada. And we have Donald K. Piragoff, Senior Assistant Deputy Minister, Policy Sector. And we also have from the Department of Public Safety and Emergency Preparedness, Francois Gaumont, Deputy Minister. From the Canadian Security Intelligence Service, we have Michael Colombe, Director. And the Royal Canadian Mounted Police, we have Bob Paulson, Commissioner. Yes. Point of order, Mr. Garrison.
Thank you very much, Mr. Chair, and I appreciate the officials are here, but we seem to be missing one official this morning, and that's the Privacy Commissioner, who is an officer of Parliament. So I would ask for unanimous consent from this committee to the following motion, that the clerk be directed to schedule one additional one-hour meeting of this committee to allow the Privacy Commissioner, Daniel Therrien, to appear before the committee.
It is a point of order, sir, and you have the floor, but you generally cannot make a motion while you have the floor on a point of order.
Mr. Chair,
yes,
I think I could do so with unanimous consent of the committee, so once again I'll ask for unanimous consent of the committee to move the motion.
And certainly Mr. Garrison has asked for unanimous consent. I look around the... Do I have unanimous consent for the motion of Mr. Garrison? Yes. No, I do not. Thank you very much, Mr. Garrison.
Thank you very much.
And we will now go to our witnesses, and of course we will have our ministers speaking briefly on giving us an opportunity to discuss the bill. And we will start off with Mr. Blaney. Sir, you have the floor.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chairman Crimp, and I will be making my presentation in our both official languages, and I invite colleagues to use the excellent service provided by our interpreters.
Mr. Easter.
I am coming back to point of order I've raised a number of times. Commissioner Paulson was before this committee and he brought written text with him. The ministers have the full staff of all the departments. There is no reason in the world why an important bill like this, the ministers cannot provide this committee with the written remarks in both official languages. I see no reason why they cannot do it. I think it's unacceptable.
Thank you very much. Yes, Mr. Blancy, please.
Mr. Chair, Mr. Easter was a minister of the Crown. Mr. Easter appeared before committee in that capacity 5 times, once before Senate committee. I believe the record will show that not once did he provide a written statement to the committee. So he's completely without credibility in raising this, and I just wish he would stop it.
Well, thank you very much. The points have been made by both sides. The Chair considers them argumentative. At this point, we're not going to discuss it further. Please go ahead, Mr. Blaney. You have the floor again.
Alors, Monsieur le...
Mr. Chairman, I'm very proud, as you know, to express myself in French. It is my mother tongue. And I will be delighted as well to make some portions of my presentation in English, Mr. Chairman. I'm delighted to be here this morning to set the record straight in various areas. I'm very proud to be here with my colleague and friend, the Honourable Minister MacKay, Minister of Justice and Attorney General of Canada. Minister MacKay, I have immense respect for him, and we together prepared this bill, and we're proud to be before you here today to protect the rights of Canadians.
The video produced by the criminal who attacked this very Parliament building and murdered Corporal Nathan Cirillo, which you viewed this past Friday. La définition du Petit Larousse est...
The Petit Larousse definition is clear. It is the one that uses Commissioner Paulson, John Kerry, Secretary of State of the U.S., and even French President François Hollande, who qualified the act committed here as being inspired by terrorism. It's an act of violence, a very obvious attack motivated by terrorism. I was here with the government caucus earlier. We were witnesses and victims of this attack on Parliament Hill. This attack reminds us, and I had the opportunity of meeting all of the members of the committee, to tell them that we must remain vigilant. and confident. And we must take the necessary measures while respecting the Canadian Charter of Rights and Freedoms, respecting privacy, to combat effectively the threat, the terrorist threat that is evolving. And it is my first duty as Minister for Public Safety to intervene. This is why I'm here this morning before you with Minister McKay to outline for you Bill C-51, which includes measures aimed at combating terrorism, but also measures that will give additional tools to our law enforcement officers, our intelligence services, but also those organizations that are doing the follow-up and the oversight of our intelligence services.
Bill C-51 is ensuring a better protection of our rights and freedoms. This bill brings more tools to tackle radicalization and track terrorists for our law enforcement and security agencies, while dramatically increasing judicial oversight and review mechanisms to protect our rights and freedoms and the privacy of all Canadians. Mr. Chair, the reality is that the international jihadi movement has declared war on Canada and most countries around the world. Canada and Canadians are being targeted by jihadi terrorists simply because these terrorists hate our society and they hate our values. This is why our government has put forward measures that protect Canadians against jihadi terrorists who seek to destroy the very principles that make Canada the best country in the world to live. That is also why Canada is not sitting on the sidelines, as some would have us do, and is instead joining our allies in supporting the international coalition in the fight against the evil ISIL, the terrorist organization Islamic State. On l'a vu à Saint-Jean, ici même à Ottawa.
We saw it in Saint-Jean, here in Ottawa. We also saw this in Paris, in Sydney, Australia, and in Copenhagen. The threat is complex and diffuse. We have the duty to take measures to protect citizens in the respect of our rights and freedoms. Violent extremist international groups like Al-Qaeda and ISIL are a serious threat for Canada. This is why we must adapt and reinforce our ability to protect our country and our fellow citizens.
Without security, pour que la liberté s'épanouisse.
In order for freedom to flourish, security and safety are essential.
Protecting security while maintaining liberty are at the heart of our conservative government's approach to national security. Canadians expect that if one branch of government is aware of a threat to their security, that this information would be shared with other branches of government to protect Canadians, not new information, already existing collected information. That's the Security of Canada Information Sharing Act, the first part of Bill C-51, a response to the Air India Commission and to many requests. Mr. Speaker, we are doing it to better protect Canadians. And the legislation has adequate safeguards built in to protect the privacy of Canadians. We are certainly not interested going to privilege the rights of terrorists over the rights of Canadians. Comme nous l'avons entendu,
As we have heard, this act will give legal authority to all departments and government organizations to communicate amongst themselves information with regard to activities that might imperil the safety and security of Canada, proactively or in response to a request from a designated federal institution with a mandate or responsibilities tied to national security. In my riding, people are telling me, Mr. Chairman, or asking rather, why is it that you haven't yet done this? By definition, under the new Act, an activity threatening the security of Canada is an activity that would threat its sovereignty, its security, or the territorial integrity of Canada, or that would threaten the life and security and safety of Canadians. Many observers have commented this definition. I would like to underscore this morning that it relates strictly to the sharing of information already existing between agencies and organizations under federal jurisdiction. Clearly, it does not relate to the mandate of CSIS. The second measure proposed in the bill, Mr. Chairman, is the Act pertaining to security air travel. This Act would set out a legal framework to define the ministerial powers under the Passenger Protection Program and broaden the mandate of this program so as to enumerate and reduce the threats from two categories of individuals. The first one we already have, Mr. Chairman. It is those people who are suspected of threatening air transportation safety. The second one, we have not yet this in place, and we greatly need this. Those who would attempt to go abroad to support terrorist-related activities are not covered by the Act. We cannot, at present, prevent them from climbing aboard a plane if we have reasons to believe that they are traveling with a view to committing a terrorist act. Yet again, Mr. Chairman, we must be clear.
In the toolbox for our national security agencies when they are combating the threat of individuals traveling abroad to engage in criminal activities. The Act authorizes the Canada Border Services Agency to collect information related to air travelers coming to or leaving Canada and screen them against the list. Having Government of Canada law enforcement officials rather than airline workers screen passengers against the list will better protect the security and privacy of Canadians. C'est un projet de loi établirait aussi des pouvoirs pour les particuliers.
The bill also sets out conditions with regard to individuals who wish to see their name withdrawn from the list. There is also an appeal mechanism provided for in the Act, Mr. Chairman. For all individuals whose name appears on the list, they can call upon the federal court and appeal. The third measure we are proposing would provide CSIS, the Security Intelligence Service, a new mandate to reduce threats against the safety and security of Canada. Finally,
security threats, but is unable to take action, unlike most of the allies are doing. With the new threat disruption mandate, CSIS will be authorized to take direct action to disrupt threats to the security of Canada, at home and abroad. Like most of our allies, such as Sweden, Norway, Finland, Denmark, France, United States, United Kingdom, and Australia. It's about time, Mr. Speaker. For instance, CSIS could interfere with terrorist travel plans or financial transactions and even intercept weapons to prevent terrorist use. It is important to note that this mandate is tied to the existing definition of threats to the security of Canada that can be found in Section 2 of the CSIS Act. This definition has been in place for 30 years and has formed the basis for CSIS' primary intelligence collection mandate since its inception. Would be the same to apply to the threat disruption mandate, Mr. Speaker. S'appuyant sur ce nouveau mandat, C-51 fixe des limites.
C-51 sets rigorous limits and establishes a mandate or a warrant mechanism for fighting threats, interfering with threats, and to my knowledge, we would be the only country in the world to add this judicial oversight, Mr. Chairman, to our mechanism to reduce threats if the measures proposed might imperil a right guaranteed by the Charter or would contravene a Canadian law. A judge of the federal court would have to authorize this ahead of time. C-51 also establishes new requirements with regard to reports for CSIS for the Oversight Committee. So we are giving the legal mandate to CERC to follow and track the activities of CSIS so as to increase accountability and transparency and the respect of the rights of Canadians. Finally, the fourth measure outlined targets Section 9 of the Immigration and Refugee Protection Act, which would authorize the government to use information obtained in the examination of immigration files and the request for non-distribution of information for the Refugee Board. These changes would ensure rigorous protection of the classified information provided, such that the procedures would be fair. We also ensure that judicial discretion be retained and the role of the special advocate, the amicus curiae, would be retained in camera sessions.
The microphone to my honourable colleague. I would like to address three key misconceptions that have been put forward by members of the opposition as well as so-called experts. The leader of the NDP has alleged that the legislation before us today means that legitimate dissent and protest will now be considered threats to Canadian security. These allegations are completely false and frankly ridiculous. Section 2 of the CSIS Act, which outlines exactly what is considered a threat to the security of Canada, is not being amended in any way by the new anti-terrorism legislation. Again, sharing of information, threat disruption. Mr. Chair, we reject the argument that every time we talk about security, our freedoms are threatened. Indeed, we believe the opposite. Canadians understand that their freedom and security go hand in hand. And the fundamental fact is that our police and national security agencies are working to protect our rights and our freedoms. And it is the jihadi terrorists who endanger our security and who take away our freedoms. Further, the leader of the NDP made allegation that I feel as Minister of Public Safety unacceptable because he said that CSIS, the security intelligence, has broken the law. This is an insult, Mr. Speaker, to the men and women who are protecting Canadians on a daily basis, who are risking their lives in unsafe place, Mr. Speaker. And for 30 years, there has been the report of the Security Intelligence Review Committee that has always provided the certificate demonstrating that they complied with our Canadian law, Mr. Speaker. I asked the member to bring coherent argument, but not insult those who are protecting us, Mr. Speaker. I asked him to apologize and keep the debate among politicians based on fact and the truth and the reality. Further, some commentators have said that the scope of the definition of activity that undermines the security of Canada is too broad and the language used is too vague for security legislation. Well, this definition should not be read in isolation. Section 5 of the Security of Canada Information Sharing Act further restricts what information can be shared by requiring that information only be shared if it is relevant to the national security jurisdiction or responsibility of the recipients. The definition was intended to cover any information that is relevant to the security of Canada, and I'm glad we have here the leader of the Green Party that have said that the provision to protect lawful advocacy, protest, and dissent do not go far enough. Well, I would invite the member to read further the legislation carefully. The Act clearly states that the definition of activity that undermines the security of Canada does not include lawful advocacy, protest, dissent, or artistic expression. First, it should be noted that the carve-out is for greater certainty and is intended to reflect the fact that these activities are not intended to be captured by this legislation. Once again, Mr. Speaker, the information that is captured by this legislation for only sharing purposes with no new information has to undermine the security of Canada. Lawful is intended to be read narrowly and to exclude legitimate forms of protest that are not contrary to criminal code. In other words, not having a municipal permit for a protest would not lead to an otherwise lawful protest being captured by this legislation. Similarly, some have said that allowing CSIS to disrupt threats to national security would trample on the rights of legitimate protesters. Once again, untrue, inaccurate, and false. Under the legislation before us today, the threshold for CSIS to engage in disruption is met if there are reasonable ground to believe that a particular activity constitutes a threat to the security of Canada, the same definition they have been using, Mr. Speaker, for the last 30 years. Previously, CSIS did not have disruption powers, allowing them only to collect and retain information to the extent that is strictly necessary. Mr. Chair, security is essential to maintaining our democratic rights and freedoms, and the Anti-Terrorism Act seeks to do exactly that. I hope that all members will support this legislation with the trust and confidence that we are taking the appropriate measures to protect Canadians and protect our freedoms and our rights. I believe personally, Mr. Speaker, that if we were to stay and not doing anything facing this evolving threat, it will be morally irresponsible and immoral. It is our duty to avoid losing human lives because of bureaucratic silos. We can fix this, Mr. Speaker. Canadians would be unforgiving should we fail to fix this dysfunctional info-sharing system, which we are probably one of the few countries that is not doing that. Better protecting the rights and freedoms of Canadians while tackling the threat of terrorism is exactly what C-51 is accomplishing. In doing so, Mr. Speaker, we have worked in close conjunction with the Minister of Justice and his department, and I'm pleased to have him do his remark. Thank you.
Thank you, Minister Blaney, and we will now go to opening remarks from Minister MacKay.
Thank you, Mr. Chair, colleagues. An honour to be here before you. I thank you for your important work. Honoured to be here with my colleague, Minister of Public Safety, Stephen Blaney, and officials from both our departments, Public Safety and Justice. As you know, we're here to discuss Bill C-51, the Anti-Terrorism Act. This bill is concentrating on a very real subject matter of terrorism, which is an increased global concern, and the Government of Canada is taking steps, and you are taking steps, to examine the tools necessary and available to our intelligence and law enforcement agencies to respond effectively to this threat. This bill represents the outcome that is crucially important in this assessment, and I'm going to focus my remarks, as Minister Blaney has said, on the Criminal Code amendments found in Part 3 of the bill. Depuis 2001, le Code criminel permet.
Since 2001, the Criminal Code has helped us combat terrorism, namely with infractions relating to various forms of participation and facilitation of terrorist activity. It also allows us to charge individuals who engage in such activities. These measures were recently reinforced in 2013 with the addition of new infractions relating to the movements of terrorists and nuclear terrorism.
We know is globally and volatile, consistently evolving, and accordingly so. This investigative package of enforcement tools available to the criminal justice system should be commensurate to that, to detect, stop, prosecute those responsible, and of course the Criminal Code reforms that are found in Bill C-51 do just that. It is an effort to modernize, to keep pace. As Minister Blaney has said, this is about giving law enforcement the ability to meet this threat, this evolving threat, and to put them in a position to detect, deter, and prevent the type of terrorism that we see and sadly expect in the 21st century. I'll speak now to those sections of the bill that fall directly under the purview of the Department of Justice. First, Section 83.3 of the Criminal Code, which targets individuals who may be involved in a terrorism activity, either directly or indirectly, currently requires 2 tests to be met for a court to impose a recognizance against an individual. This bill proposes to lower the threshold of both these tests from requiring police to have reasonable grounds to believe that a terrorist activity will, with emphasis on will, be carried out, to may be carried out, imminent to possible, and from reasonable grounds to suspect that conditions are necessary to prevent the carrying out of terrorist activity to likely to prevent the carrying out of the terrorist activity. Lowering the threshold seeks to make it easier to obtain the recognizance for police to do so and then appear before a judge. So it's important to emphasize the judicial oversight component of this. Bill C-51 would also increase the maximum period of time that a judge can remand an individual awaiting a recognizance hearing from a total of 2 days to 6 days, with a 24-hour police detention period remaining the same. So, in other words, to expand that period of time in which investigations can occur and certain conditions can be in place to protect the public. So up to 7 days. This bill also proposes to strengthen the existing terrorism peace bond in the criminal code. The bill proposes to lower the threshold from the current requirement that a person must fear on reasonable grounds that someone will commit a terrorism offence to fear that they may commit a terrorism offence. This change seeks to make it easier to obtain the peace bond. So there is a scale here where we are lowering the threshold to allow the police, with judicial oversight, to put in place conditions to protect the public based on evidence. It would also extend the maximum duration of the peace bond from 2 to 5 years for those previously convicted of a terrorism offence. Furthermore, Chair, for both recognizance with conditions and peace bonds, the court would be authorized to impose sureties and to require judges to consider geographical and passport surrender conditions, so behavioral controls, if you will. The penalties for breaches of these court orders would also be increased from the current 2 years maximum to 4 years. And Bill C-51 would also propose to amend the criminal code to create a new indictable offence for knowingly advocating or promoting the commission of terrorism offences in general. The offence would require that the person either knows that any of those offences will be committed or be reckless as to whether any of those offences may be committed as a result of that communication. This new offence would be punishable for up to 5 years imprisonment. The new offence would fill what we believe is a current gap in the law and is responding to a current threat that exists. Currently, it is a crime to counsel someone to commit a specific crime like murder. It is not a crime, however, to counsel somebody to commit a broad category of criminal activity like terrorism, one lacking specific detail as to which offence is being encouraged to be committed. Therefore, the focus of the proposed new offence is to cover the situation where the active encouragement lacks the specific detail that would link the encouragement to the commission of a specific terrorism offence, although in the circumstance it is clear that someone is actively encouraging a person to commit any of the terrorism offences in the criminal code. So in other words, it would not matter whether a specific terrorism offence is advocated or promoted for criminal liability to attach. To be clear, this is not a glorification of terrorism offence. Related to this new offence is the proposal to create 2 new warrants of seizure in relation to terrorist propaganda. One for terrorist propaganda in a tangible form, such as a poster or a flyer, and the other for removing terrorist propaganda disseminated and stored on a website located in Canada. So obviously, we work within our own jurisdiction. This does not afford us the ability to capture this material from outside the country. Similar powers already exist for other materials that Parliament has determined to be harmful, including hate propaganda and child pornography. So it mirrors the criminal code sections already in existence. Most parents, I think, would know that we are doing this in the best interest of removing material that could be used to radicalize or recruit a young person. And in fact, in talking to people about this particular section of the code, some were alarmed to know that we don't already have the ability to remove this offensive material. Finally, changes are proposed to better protect those involved in national security prosecutions and proceedings. And among other things, these changes would provide better discretion of the courts to make orders that reflect security needs of witnesses. So in particular, we're talking about participants in the justice system who might find themselves vulnerable as a result of the individuals that we're dealing with. This is not unlike what we've seen in prosecutions of gangs or organized crime. It takes into account their role in relation to national security matters, while at all times respecting the fair trial rights of the accused. These legislative proposals and those of my colleague, Minister Blaney, are reasonable and a proportionate response to the threat of terrorism in Canada. They contain a number of safeguards, including judicial oversight and discretion for the many tools that we have discussed and presented here this morning, the requirement to obtain Attorney General consent before proceedings, and annual reporting requirements on the use of recognizance with conditions. These are tabled in Parliament, as I did just recently in December. And, Mr. Chair, this is also, these provisions, peace bond and recognizance conditions, are subject to sunsetting. That is to say that the law, when it came into effect in 2007, will be reviewed with respect to those recognizance peace bond conditions in 2017. In providing these new enhanced and judicially approved measures which respond to terrorism at home and abroad, we believe we are doing so within the existing and overarching legal framework that respects the Charter and includes important checks and balances. So to conclude, from a criminal justice perspective, this bill will address gaps in the law, only target extremely serious conduct, and clearly defined offence elements and a high level of mens rea. Mr. Chair, I would just end with a quote from the Queen and Kawaja, which is an Ontario Court of Appeal case, where writing for the majority, Mr. Justice Moldaver, as he then was, said, "To be sure, terrorism is a crime unto itself. It has no equal. It does not stop at, nor is it limited to, the senseless destruction of people and property. It is far more insidious in that it attacks our very way of life and seeks to destroy the fundamental values to which we ascribe, values that form the essence of our constitutional democracy." Chair, I thank you for your important deliberations on this legislation. We look forward to your questions here this morning. And again, we're very appreciative of the work that you're undertaking. Thank you.
Well, thank you very much, Minister MacKay. And we will now go, colleagues, to our rounds of questioning. First round, 7 minutes, and we will start with Parliamentary Secretary, Mrs. James.
Thank you, Mr. Chair, and thank you both ministers for appearing and the officials that are here as well. Canadians would expect, Minister Blaney, that when one branch of government comes across information pertinent to national security and the protection of Canadians, that agency would be able to communicate that information freely to another agency such as the RCMP or CSIS. However, that is clearly not the case today, and I have to tell you, I was probably one of those Canadians that thought this was already being done. So I find that this legislation with regards to information sharing is absolutely critical. Both Minister Blaney and Minister MacKay, in your opening remarks, you talked about identifying gaps that were brought forward by our national security agencies. Minister Blaney, if you could expand on some of these gaps, focusing in on information sharing and why this part of the legislation is so important.
Well, thank you for the question. Maybe I can begin with 2 examples as what is the current situation now. Is that if an individual, like we've heard lately that in Montreal, 2 young girls were willing to travel, were allegedly said that they have left the country to commit terrorist attack abroad, and they show up at the passport office. They've asked for an accelerated process within 48 hours. They said that they had lost their passport, and they said that they wanted to go in the Middle East, in a region, as you are well aware, that there's many conflict. So this information should raise some concern in terms of national security. Canada is not and does not want to become an exporter of terrorism. As we speak, this information cannot be shared with relevant authorities such as the RCMP or the security agency CSIS. So this bill will enact the department to undertake this kind of action. And the other example is on the other side. If we take a wounded person coming at the consulate in the Middle East, willing to come back and seeking some information, being obviously wounded or having spent some weeks out there in the desert, well, this may raise some reasonable doubt. But again, this information may not be shared to the police officer, nor to the Canadian Border Service Agency, nor to our intelligence. So a potential individual, a potential high terrorist traveler who have had a comeback experience could come back in our country, and we could hardly prevent it. So these two examples demonstrate clearly the need we have to make sure that the left hand of the government know what the right hand is doing. But in doing so, let me assure you that there are many mechanisms to protect the privacy and also the Constitution. First, I think I've stated clearly that it has to be an information that would constitute undermine the security of Canada. So before an information is carried, there has to be a risk, and it has to be transferred to an organization that is relevant. And again, this is not a new information. This is an information that is already being collected by the government, but that is not being shared. And are we to let silo being used by terrorists to arm Canadians? Frankly, I think this is totally irresponsible. And that's why when I speak to people in my writing or elsewhere, people are telling me, how come you have not done this before? How come you are not sharing the information in a respectful and lawful process? Well, this is what we do. And also, this is important to specify, and it's in the bill, that the information has to be done in respect, of course, of the Canadian Charter of Rights and Freedoms, and also the protection of privacy. And this is actually in the enactment of the Act. So we already have many legislation, but we felt it was important to specify it in the bill. So I can comment further. I think you want to ask some more questions.
Thank you. I just wanted to go back to, there's been some concern from the opposition and from the Green Party with regards to a section in the Information Act that clearly states that the information sharing would not relate to lawful advocacy, protest, dissent, and artistic expression. Now, the concern seems to be surrounding the word lawful. I just have to ask a very simple question. How bizarre would it be for a government to legislate this type of a bill and include the ability for unlawful advocacy? I just have to ask that question because obviously lawful, unlawful, there's a big difference.
Okay. Well, I thank you for the opportunity you are giving me to clearly clarify what is in the bill and what is not. Once again, there's the Information Sharing Act, where information that could undermine the security of Canada could be transferred. This has nothing to do with the other part of the Act, like the threat diminishment, which rely on the current definition of terrorist activity. So it has no impact at all on this aspect. The only thing the legislator is doing in crafting that bill is any information that could undermine the security of Canada has to be sent to the recipient institution. And of course, there's another safeguard here, because if the information is received, it has to be irrelevant to the specific department. So that's another, if I can put it that way, safeguard. But once again, to get back to your definition, there are lawful activities. There are unlawful activities, and I gave this morning the example of a protest that would not have a municipal permit. This is not, I would say, included, I would argue, in that bill, which undermines the security of Canada. So once again, it could be an illegal activity, but not necessarily shared, because it does not undermine the security of Canada. So I think we clearly see this morning that there are lawful activity, could be illegal activity that does not undermine the security of Canada, and there are those activities which we feel that is important to share, that are specified in the bill, and there are some examples, like I see here, espionage, sabotage.
We'll just have to cut you off, and you'll have an opportunity to go further a little bit later on, but we're over the time. We will go now to Mr. Garrison. 7 minutes, please.
Thank you much, Mr. Chair, and thanks to all the witnesses who are here today. And I know for the Minister of Justice it's relatively rare to appear in this committee, so a particular thanks to him for being here today. And I want to start with a question to him. There has been a lot of public concern expressed by legal experts, including former judges, about the broad nature of the new offence in the criminal code, about the lower threshold for detention and peace bonds, and about fundamental changes to information sharing that might affect privacy rights. So my assumption is that the minister would not bring this legislation, obviously, before Parliament. He does not believe it's constitutional, and that he must have received advice from his officials on the constitutionality of this bill and its provisions. So my question is, would the minister be prepared to table the advice he received on the constitutionality of this bill? Because it would be very useful for this committee to avoid further legal entanglements down the road if we could have that advice tabled for us so that we could use it before we reach the amendment stage of this bill.
Thank you very much for the question, Mr. Garrison. Colleagues, while it may be rare that I appear before this committee, this is my 52nd appearance before a committee as a minister. The member's absolutely right in suggesting that we would not have introduced a bill, and certainly from a justice perspective, no bill is introduced to Parliament unless it has been drafted and presented to Parliament in a way that is consistent with the Charter and the Constitution. So every bill receives that vetting, that lens, from the Department of Justice prior to its introduction. Officials with the Department of Justice, of course, have expertise in that area. In fact, some members of our department go back to the drafting of the Charter itself. We have tremendous legal advice that is available to all departments. And so, yes, the member's correct. I would have met with and worked with my department to ensure Charter compliance. The Supreme Court of Canada, of course, has recognized that the prevention of terrorist acts is a valid state objective, given the grave damage that can result, and that was the quote that I was presenting to you at the close of my remarks. So this is not to say that all legislation that is presented to this committee, to all committees, is not subject to Charter challenge. But we anticipate and look at various aspects, including privacy, to come back to the member's question, and do so to ensure that we believe that ultimately the courts will pronounce favorably on the Charter compliance. But with regard to presenting that advice to this committee or any committee, I'm not able to do so as Minister of Justice and Attorney General, as there is a solicitor-client privilege that exists between the Department of Justice and the Department of Public Safety in this case.
But of course, as the person who is the beneficiary of that solicitor-client privilege, you could waive that and table it before this committee.
And we're not going to do that. And of course, the privilege doesn't rest solely with me; it rests with the entire government.
Okay, thank you very much. I still believe we would benefit from having that information before us. I want to turn to Mr. Blaney, who said that he welcomed the opportunity to clarify things today. So I have two questions about the new powers that have been given to CSIS in this bill. The minister has said many times in public and in the House that the new disruptive powers of CSIS would require a warrant from a judge. And so I would like him to clarify, because my reading of the bill and that of many others does not say that. It says that disruptive activities may be conducted and they'll require a warrant only in certain circumstances. So I'd like him to clarify that part. And the second thing that he said very often is this amounts to judicial oversight. So since the warrant being sought is for activities conducted in secret and not leading to a criminal charge, how will the judge ever see what happened with that warrant again? How would that warrant ever end up back before the courts so they could exercise oversight? I don't see any provision there once the warrant is granted that would allow a judge to examine what had happened with that warrant. And I have to say, just briefly at the end of that, that when Mr. Blaney says that the NDP is, of course, attacking police and CSIS members, we're not. What we're saying is that occasionally agencies make errors and they end up before the courts. And we had the Mosley case, which clearly said that CSIS had, in some cases, made errors that constituted a violation of the law. So my question, very specific, does disruptive activity always require a warrant, and how will that warrant ever get back in front of a judge?
Well, I thank you for your question, and you certainly heard me again this morning clearly say that a warrant is required every time that there is a legal consideration. I'll just refer to what I've said earlier this morning. S'appuyant sur ce nouveau mandat.
Relying on this new mandate, C-51 sets rigorous limits and establishes a warrant mechanism. If the measures proposed risked imperiling a right guaranteed by the Charter or would contravene a Canadian law, a judge of the federal court would have to authorize this prior to this taking place. So I'll be clear this morning, yes, a warrant will be required with C-51 every time the rights or the Canadian Charter of Rights might be implicated. So I hope I have answered clearly your first question.
You just proved my point. You said it's required only if there's going to be breaking of a law of the Charter. Other disruptive activities then are clearly authorized without a warrant.
Effectivement, il y a certaines activités.
Indeed, there are some activities, dear colleague, that do not or will not require the obtention of a warrant. However, the threat reduction or disruption activities based on their impact must follow a rigorous process. And you know that as Minister of Public Safety, I will eventually have the ability to authorize warrants, and those who will follow me as well. And I will rely here on the advice of the Department of Public Safety. I will give you an example this morning of a case where you would not require a mandate. For example, the intelligence service agents might engage in a conversation with the parents of a child who is being radicalized. In that case, a warrant would not be required.
Now we will go now to Mr. Norlock, please, sir.
Thank you very much, Mr. Chair. Through you to the witnesses, thank you for appearing today. My first question will be to Minister McKay. Could you explain the gap in the legislation you're trying to fill? And I'm referring mainly to the promotion and takedown thresholds with regard to Internet sites. We've heard some folks say that this portion of the legislation is an attack on our freedom of speech. I don't believe it is, but I do not believe that promoting the Commission of Terrorism Acts is acceptable. And could you explain the legislation and how it is different than the current hate speech laws that are focused on certain groups? Thank you very much for the question, Mr. Norlock. As you'll be aware, there are current sections of the Criminal Code, and you've alluded to them, where certain types of material, certain statements, certain speech is deemed to run up against other charter rights. And so what we're attempting to do here is, through the criminal law, balance out those freedom of speech provisions, privacy provisions, versus material, words that can be, in fact, very harmful. The examples of hate propaganda, advocating genocide, and, of course, the area of child pornography is well understood. With respect to the advocating or the promotion of terrorism, we believe that the current criminal code as drafted is insufficient in allowing us to protect the public from the very real, and I would describe it as corrosive effects of terrorism and the promotion of same. And so what we are doing through this legislation is enabling our system, our criminal justice system, to respond appropriately, to ensure that that material, when deemed to fall into that category, is subject to removal. And to meet that test, we know that there is a requirement to make applications before a judge to view, to weigh that material appropriately against other rights, and then make a determination. The wording is drafted in a way that any offenses that would be laid, any charges that would be laid, take into consideration things such as recklessness, which is another legal standard to be applied. And the proposed offense is not focused, as I said in my remarks, on what has been somewhat controversial in other countries, and that is the subject of glorification. So the standard to be applied here is the promotion or the advocacy, so the encouraging, the efforts to actually draw a person into committing acts of terrorism. And what we're doing here, these terms of advocate or promote, some have said are quite vague. There is case law in this area already, so there is existing jurisprudence that is instructive in that regard. We have a number of Canadian cases that I could cite for you. Keekstra in 1990 is a well-known Supreme Court case that goes into the area of promotion and speaks of active support or instigation. A 2001 Supreme Court case of the Queen and Sharp involving possession of child pornography talks about advocating. And so this bill, C-51, reflects the Supreme Court's definition that already exists when it comes to terms such as advocacy and promotion for offences. It's the idea of counseling or inciting, and that material then to be viewed leads to that type of encouraging or incitement of terrorism.
Thank you very much. My next question will be to Minister Blaney.
You wish to comment on that, I do believe.
If I may, Mr. Norlock, your question, and I want to salute the measures that Minister McKay just explained, because as you know, our government has tabled a counter-terrorism strategy that has 4 pillars: to prevent, detect, deny, and response. And the fact that as a government, as a society, as we will be able to shut down those websites who are promoting hatred and violence is a tool helping us in the first pillar of prevention of radicalization, because as we know, we've heard it, the Holocaust did not begin in the gas chamber, it began with words. So we have to be careful, and that's why this measure, I feel, is so important. And I also am committed, as Minister of Public Safety, to work with my partners, such as Minister Bernard Cazeneuve of France, our European partners, American, so that website that could be hosted in other countries could also be shut down if they are promoting hatred, extremist ideology, and violence. So I believe this measure, 51, is helping in the 4 pillars of our counter-terrorism strategy. Thank you.
Thank you. My next question will be, and Commissioner Paulson can come in if he feels so. We heard on Friday Commissioner Paulson, who came before the committee, and we viewed the tape, of course, of the murder of Corporal Nathan Cirillo. And I'm during the answer and question period, he indicated that he was able to receive passport information in this particular case, and the information sharing was sufficient. Could you tell us through which mechanism that would have occurred, and some of the gaps that this legislation closes with regard to information sharing?
Okay, well, Mr. Chair, I think going back to Friday, I would want to, claim the discussion on that was around Mr. Garrison's suggestion that the collection of evidence that would have led to this imaginary charge that I put forward in my comments around had Mr. Bibeau not been killed, we would have charged him, was in the sort of post-event collection of information and not in the sort of real exchange of information, because once the act took place, of course, everybody was happy to share information, and the information was flowing rather well. So I think that is hopefully clarifying.
Thank you.
Thank you very much. And now, Mr. Easter, you have the floor, sir.
Thank you, Mr. Chair, and thank you, ministers and officials for coming. Before Minister Blaney, I get to the more substantive, a minor issue, but I think an important issue. You indicated that the appeal process and the no-fly lists, and I think all of us, or most of us as members of Parliament, have had some experience with trying to get people off a no-fly list. And you talked about the appeal. And in the legislation it says that the minister does not make a decision in respect to the application with 90 days. Then a little wording there. The minister is deemed to have decided not to remove the applicant's name from the list. That's really not much of an appeal process, Minister. You do not even have to respond. And so I think it really, you need to consider an amendment in that regard and go the other way, that the minister must respond within 90 days. Then to the more substantive, you said in your remarks that you're dramatically increasing judicial oversight and review. In response to Mr. Garrison's remarks, you said a warrant is required every time there's legal authorization to. I submit that a judicial submission to carry out a certain act is not, in any sense of the word, oversight. It's authorization before the action happens. And maybe you could explain that process. Where's the oversight after the warrant is granted?
Well, I thank you for your question, and once again, I think it's another opportunity to clear oversight versus review. We would be, in terms of threat diminishment, the only country that is involving this warrant issued by a judge when they're conducting activities that could have an impact on the Charter of Rights or on the rights of Canadians or their privacy. So the fact that the judge is involved, because in the warrant, the activity that would be conducted will be described. And the judge could even ask for a third party to bring some different views. So we are actually the only country, because all the others are only and strictly keeping administrative oversight. So this is oversight. So this is oversight, and then, as you know, we have a review mechanism. But once again, we have a warrant. There's a judge that has to be consulted and to authorize, and the judge can also modify the mandate if the judge would have any concern. So he can refuse, modify, he can ask a third party, or he can also ask for a third party or refuse.
That is not oversight, and your colleague to the righty, Minister McKay, knows that's not oversight. He and I sat on a committee together. We did a lot of traveling together, and I will admit, Minister McKay, at the time you were one of probably the most enthusiastic people for parliamentary oversight, similar to our Five Eye partners. Minister Blaney, you can say that no other country provides the judicial warrants, but your explanation confirms what I claim, that that's only authorization to do A, B, C, D. You also know Judge Mosley's decision, which indicated that CSIS was not quite as upfront with Judge Mosley as they had indicated, and he corrected them on that, and he came out quite angry about that they had went further than they were authorized to do. And those things happen. It makes the point that judicial authorization is not oversight, it's not adequate. Canadians want to see oversight, and I have to ask Minister McKay, who sat on that committee with me in 2004, which ended up with Bill C-81. We were to the UK, Washington, etc. and we called for that. Why was Minister McKay why were you so supportive then, Minister? And now you think with all these additional powers for CSIS, the RCMP, criminal code, etc., that we don't need oversight in this country that is for all of our national security agencies. We need it. We need it worse than we ever did.
Well, let me begin by stating, Mr. Easter, I recall well being part of that committee as an opposition member. You, of course, were a member of the government and didn't take the opportunity to act on those recommendations. And in fact, you were in government for, I believe, 14 years, and as a government never enacted those oversight recommendations that you so enthusiastically embrace today.
2004?
However, in 2004, you were a member of the government, so you had a mandate to do something about it, and you didn't. You failed. So the truth of the matter is, looking at those examples around the world today, the real oversight comes, and I think you would be quick to agree as a former Solicitor General, the real oversight comes from those with expertise in the area of security. I think you would agree with that. Those who have had experience in the field, those who have had legal experience, training, judicial experience, and I would suggest to you that when you examine some of those examples, including in the UK, I was recently in London, and you're seeing now their Parliamentary Oversight Committee coming under a fair degree of criticism because they've been subject to political interference, scandal, in fact, that has undermined that Parliamentary Committee's objectivity, perhaps, and the ability to do the actual job that we would ask of them. So I also note that, you know, on the area of expertise, you yourself are quoted in the paper in the context of this examination of the bill as saying, we're not experts. We're there to listen and to learn. And so I think, on balance, if we want to have true oversight, we need not only to have a mandate, but we have to have people in those oversight positions, like CERC, that have the ability to ask the proper questions, to delve into the detail that's necessary.
Former politicians
and be
on
able to
CERC,
report.
Minister, come on. Former politicians on CERC, yes, we need expertise.
Thank you very much. We will now go to Madame Doré Lefebvre, s'il vous plaît.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chairman, and thank you to the Minister of Justice and the Minister of Public Safety for being here, as well as all the other witnesses. It's greatly appreciated to hear you all regarding C-51. As we say in French, it's better to prevent than to care for after. When I looked at the bill, I found that what was missing the most in what was put forward, or one of the things that is most missing here, is really a national strategy against radicalization. I'm mentioning this because I'm looking at what is being done, for example, in the U.S. The government is working a lot with communities on the ground to ensure that they have a good strategy against radicalization. Last week, a few days ago, the mayor of Montreal began working on a strategy against radicalization with the players on the ground, the police forces, the community leaders. And I was wondering if perhaps Mr. Blaney or Mr. McKay, you might have answers for me, perhaps more the Minister of Public Safety. I'd like to know what you're doing at present concretely against radicalization. You talked of several issues. You gave a few specific examples, but overall, what are you doing concretely to combat radicalization? Because you're working, are you working with community leaders? Are you working as you should with the police forces? What resources have been devoted to this? Thank you, first of all, for your question, which is very relevant. I must tell you that I'm somewhat disappointed that we have not received the support of your political party, and I would say respectfully that the NDP is behind, because our strategy to combat terrorism has been in place for 2 years, and we didn't get the NDP's support to put it in place. So I find this somewhat surprising that an NDPer is waking up 2 years later, 2 years down the road, saying or asking, what are you doing prevention-wise? Listen, we have to pursue our efforts prevention-wise. We are working, Minister McKay and myself, we sit on round tables, cross-cultural round tables, and it is obviously important to make prevention efforts. It's the first pillar of our strategy. And I had the opportunity to provide to you last fall before the attacks that took place here in Ottawa. I gave you our anti-terrorism strategy pillars. Commissioner Paulson is making remarkable efforts. I have a document here that you can get on the internet. It outlines our strategy for youth against radicalization. It was published quite a while ago. It is 20 pages long, and it describes the strategies we're putting in place, the meetings that we're holding throughout the country with communities, with community leaders, and obviously there is information provided to officers, law enforcement staff, but our approach for prevention has 3 pillars. There is the commitment with communities, there is training, and there is also the articulation of a counter-narrative message. I was in Washington a few weeks ago. We're working with our British partners that have very interesting initiatives underway, but also the municipal police forces in Toronto last week. I was with police officers who established tactical intervention groups to prevent radicalization. So this is an effort throughout society that we are leading. And the Commissioner might wish to say a few words. I know that you don't have much time, but the Commissioner will outline what the RCMP is doing to prevent radicalization. Thank you, Minister. As I was saying Friday, our prevention program is quite complex.
Prevention strategies are founded on legitimate community engagement. I spoke of the Counterterrorism Information Officer Program, which is years old now. We've trained over 1,800 CTIOs across the country, and that's not just in the RCMP. That's in police forces, partner police agencies, and those officers have as their mandate engagement, information sharing, training officers to what to look for radicalization, community, as I say, community engagement. In the last little while, working with partners of public safety and other police forces, we've begun to bring our sort of crime prevention strategy to terrorism prevention. In other words, hubbing the resources that exist at the local, provincial, federal level, working with those communities to try and understand and identify early who's at risk, and then bring to bear other strategies other than the criminal justice response in that pre-criminal space. It's proving very effective. In fact, as the Minister said about Toronto, we've piloted it with the Toronto Police. We're working with other police forces. We're doing it ourselves, and it is paying some dividends.
Thank you very much, Commissioner and Minister. And now we will go to Mr. Blonsky. 5 minutes, please.
Yes, thank you, Mr. Chair. I think a lot of Canadians will remember the debate about a little over 30 years ago when the Liberal government under Prime Minister Trudeau brought in the act that created CSIS. Immediately, there were voices of protest and fear raised. 30 years ago, when CSIS was created, there were allegations that the creation of this civilian security agency would be a step toward a police state. 30 years ago, the naysayers said that the Canadian Civil Liberties Association said that no Canadian will be safe from being targeted. 30 years ago, the Ontario government said that the CSIS will have unlimited and unchecked powers, carte blanche to break every law in Canada. But we know today that there are many activities that threaten Canadian security that do not fall under the criminal code and therefore under the mandate of the RCMP, and that we value CSIS and the work it does. One example today is criticism of the expansion of the Passenger Protect program, Minister. The NDP, for example, say, well, it's already illegal to travel abroad to join in terrorist activities. So I wonder if you'd speak to that and why you believe the mandate of the Passenger Protect program needs to be expanded.
I thank you, Member Ablancy, for your question. And it seems, as we were seeing, like the history repeating itself in some way, where some people are bringing, I must say, really fallacious narrative. And that's why I'm proud to be here this morning to talk about the bill for what it is and not for what people may think or would like it to be. And this is a very important exercise, as you are to undertake. This committee is to undertake a review over the course of the next month. And I expect, I think, as Canadians, we expect to base our conversation on facts and on reality. And frankly, I'm quite confident that Canadians clearly understand the goal of that bill, which is to protect the rights and freedoms of Canadians, their privacy, while providing tools to those who are there to protect us, as well as providing tools to those who are watching, those who are there to protect us. So that's what C-51 is all about. There are robust oversight and review mechanism. We would just give the example that we're one of the few countries that will need a judicial oversight for threat diminishment. And once all these activities have been conducted, there is a strong review. And let me just quote you what our Security Intelligence Review Committee has said about their work and how they see their works in terms of reviewing the work that has been accomplished, and what they like to have this distance so they can really have a critical eye on the operation of our intelligence community. They said that our model of ongoing and methodological review also has the distinct advantage of allowing for a full and impartial assessment of our Canadian Security Intelligence Agency performance, arguably better positioning it to detect potential problem earlier. So we have 30 years of independent expertise, knowledge, without political interference, without even government interference, because they are fully independent. They are actually lawyers, researchers that have the continuity. Some of them have worked into the intelligence community. And you may have heard the director himself yesterday saying that he was fully staffed to do the important work he has to accomplish. Now, to get back to your passenger protect question, it's fairly clear. What?
Very briefly.
Okay, well, this act was passed when we got the attack on the World Trade Center of those who want to attack the safety of the airplane. Now we need to be able to arrest those, even though we cannot lay charges, but we have reason to believe they will conduct terrorist attack. We need to be able to prevent them from traveling. That's why we need to ask to add the high-risk traveler on our no-fly list.
Fine. Thank you very much, Minister. And now Mr. Garrison, 5 minutes.
Thank you very much, Mr. Chair. I've expressed my concerns before about overinflated rhetoric when it comes to this bill, and I heard the minister earlier make a reference to the Holocaust, and I would assert that there's no equivalence to anything we're talking about here today to the Holocaust, and at best the reference seems to trivialize the Holocaust. So I'd like to offer the minister an opportunity to withdraw that comment.
Je vais vous répondre en français.
I will answer in French. Violence starts with words. Hatred begins with words. I could talk to you about the Rwandan genocide that began on the radio and contributed to a horrible genocide. A former senator here even suffered mental health issues because of that. Let's call a cat a cat. Rhetoric, discourses that are against Canadian values, hate propaganda has no place in Canada. And as a government, the time has come for us to take our responsibilities and not tolerate the language that is irrespectful, violent, and hateful that we've been hearing. This is what this Act allows us to do. So I maintain my statements, what I've said, and I would repeat that the Holocaust did not begin in the gas chambers. It began with words. This is why it is important to respect the rights and freedoms of Canadians, but to not tolerate insightful, or rather, the encouragement of violence.
The Canadian Human Rights Commission to remove hate crime materials from the internet. your government sponsored and passed a bill through this House and through the Senate that took away the power of the Human Rights Commission to order the withdrawal of hate crimes material from the internet. Why did you do that then, and why are you advocating the opposite now?
Monsieur Garrison, ce matin, ce que je vous dis, c'est que le projet...
What I'm saying this morning, Mr. Garrison, is that the bill will allow us to withdraw, to take down websites that carry out hate propaganda and any form of terrorism, no matter the source. There is no room in Canada for the promotion of violence. It's as simple as that. And this is what the Act provides for. I don't know if you agree with me this morning, but if you click on the Internet, if there's a website in Canada, housed in Canada, that promotes jihadism, if it says, kill all the infidels throughout the world, I believe that this flies in the face of Canadian values, and we must do everything we can as politicians to combat this. This is why, yes, I agree that we must pursue our measures to combat terrorism, prevent radicalization, and this is exactly the reason why I invite you to support Bill C-51, because it is the right thing to do to protect the rights and freedoms of Canadians, and also to protect us against the terrorist threat.
The difference between the powers you took away from the Human Rights Commission and the powers you're suggesting today.
Let me just clarify that, Mr. Garrison. As you know full well, hate promotion, propaganda, genocide, this is covered in the Criminal Code of Canada. And anyone engaged in that type of activity is subject to prosecution in Canada. So let's not leave any impression, I know that's not what you're trying to do, that somebody is going to be free to carry out that type of heinous activity in Canada and not be subject to charge and prosecution. It's in the Criminal Code.
I want to go back to the question of oversight. And again, when I was asking the Minister, the warrant authorizes this disruptive activity if it involves illegal or unconstitutional activity, but he didn't get a chance to respond to my question of how does that ever get oversight from a judge? Once that warrant is issued, how does that ever get back before the courts? Because you talk about judicial oversight. I don't see any way, in contrast to when the RCMP uses disruptive tactics as part of a criminal investigation, that ends up back in front of the courts, and the courts do get to see that. But in this case, it's secret activities not aimed at criminal prosecutions, so will not appear before the courts.
Well, I thank you for your question. And as you know, we now have the Canadian Security Intelligence Service for more than 30 years. And in my capacity of Public Safety Minister, and Mr. Easter had the opportunity to do so also in the past, we already have a judicial oversight that relates to collecting information. And this goes through a robust oversight mechanism. First, when CSIS is willing to collect activity that would seek a warrant, they have to submit their proposal to the Public Safety Department. And there are more than 1,000 people working at public safety with experts that have the experience to validate. And those people are giving me a recommendation on whether or not I should accept the warrant to collect information. Those activities are
Mr.
conducted...
The question is afterwards. How does this get back before the courts after the warrant?
Well, what I want to tell you is that we're conducting those activities. We've been already conducting those activities for 30 years. Afterwards, what happens? Where we have oversight, we have review body, we have the Security Intelligence Review Committee, and I just quoted you how the role of SERC is important, but let me give you another quote this morning.
And we will now go to Mr. Payne.
Okay.
When I hear the quote.
Thank you, Mr. Chair, and I'd like to thank Ministers McKay and Blaney for coming along with their officials. Certainly this is a very important piece of legislation, and Canadians expect their government to protect our citizens as well as make sure that Canada is safe and secure. And Minister Blaney, if you'd like to go ahead and do that quote, I'd be more than happy to hear it.
Sorry. the chair is tough on me this morning, I must say. Okay. Well, what I want to say, and this is really important because, you know, our system is based on trust. Trust. You know, as politicians, we get elected because politicians trust in us, actually. And it is important to maintain that bond of trust, the trust of Canadians toward their institution. Are they perfect? No, they're not. Are politicians perfect? They aren't either. Well, that's why we have mechanism to review and see if there has been mistake. Has there been mistake in the past? Yes. Will there be mistake in the future? There could be, but we must ensure we do anything to avoid it. Now, the quote I want to give you, and I'm going to give it to you right away, is about the Security Intelligence Review Committee. They are this Canadian model design 30 years ago that is keeping an eye on our intelligence community. They are expert, they have an independence, they don't have political interference, and they have the knowledge and the expertise to conduct their activities. And they have a deep understanding and knowledge of CSIS. You just have to read the report to know how deep they can go. And actually, this is the mandate we given them, the parliamentarian. They are actually an extension of Parliament. CERC is an extension of Parliament. They are acting on our behalf, and they are reporting to this very Parliament. That's what our Security Intelligence Review Committee is. Well, this Security Intelligence Review process is an example of the Canadian legal system striking a better balance between the protection of sensitive information and the procedural rights of individuals. Who said that? The Supreme Court of Canada.
Pretty good quote. Thank you. My next question is for Minister MacKay. And Minister, in your opening remarks, you certainly talked about lowering the thresholds for recognizance with conditions. And I guess as part of that process, I'm wondering if you could sort of tell us why you believe that's an important, and do you have any kind of examples where law enforcement could have used this to benefit them in the past?
Thank you very much, Mr. Payne. The reality is that the peace bonds and recognizance are a tool, to borrow a phrase from Mr. Blaney, that the police are able to use in a preemptive manner. So the classic case where you see an example of an individual exhibiting behavior that would be consistent with someone who's been radicalized, somebody who may pose a threat, someone who may be, for example, subject to this type of activity in the future, the police are able, based on evidence, to go before a judge and seek a recognizance or a peace bond, depending on that evidentiary burden, depending on the behavior, and put in place, through the judge, certain conditions that the individual has to comply with. And those could include such things as forfeiture of passport. It could include conditions of reporting, to stay within a certain geographic area, to not associate with certain individuals, not to be in possession of weapons or explosives. And so you can see that these are two mechanisms through the law, through a judicial exercise, that allow us to put controls in place prior to the commission of an offense. And by lowering the thresholds, we gain greater access to those conditions and controls. It has been said in the past, and the argument, I believe, has been successfully made, that in cases of terrorism, where the potential for harm, grave personal harm, is so real and perhaps imminent, that lowering the thresholds to gain greater access to these tools is what we hope to achieve. And that is what is encompassed in these sections of the bill. Along a continuum, lowering the thresholds to have recognizance and peace bonds in place, we believe will empower the police to make the right decisions with the judicial authorization, to put in place conditions that we hope will absolutely prevent and deter terrorist acts in Canada.
Fine, thank you very much, Mr. Payne. Et maintenant pour 5 minutes, Madame Doré-Lefebvre, s'il vous plaît.
And now for 5 minutes, Ms. Doré-Lefebvre. Thank you, Mr. Chairman. And I would like to pursue the issue of the oversight of CSIS, if you'll allow me, because I believe there are several questions that remain unanswered in this regard. At present, the civilian oversight organization that oversees CSIS provides a report after the fact. What I'm wondering is this. With the new powers you will be granting CSIS under C-51, who will be ensuring the oversight in real time to ensure, in fact, that CSIS respects the mandates, the warrants? Because here we're talking about a lot of new powers for CSIS, and the Civilian Oversight Committee delivers one report per year after the fact. So once again, will this be coming after the facts, or will something be done in real time so that we know what's going on? Well, listen, the answer is very simple. The Canadian Intelligence Service is subject to all Canadian laws, the Canadian Charter of Rights and Freedoms, the Canadian Charter of Rights and Freedoms, the Privacy Act, and all other laws of the country. It might be important this morning to state that in the threat reduction activities provided for in the legal framework, in no case can you endanger the physical integrity of a person or threaten his or her physical health. Mr. Minister, I would like to know where we're at with this, because I think that it is something that a lot of experts have brought up over the last weeks, and it's very important. What is the situation with regard to civilian oversight? Are we going to retain what we have now, which comes after the fact, or will there be mechanisms? Do you think it's important to have real-time mechanisms to know what's going on? This is what I'm explaining to you. We have both. We have two mechanisms. We have belts and suspenders. We have a continuum mechanism. We have to ensure that the laws are respected by CSIS. So intrinsically, their duty is to respect the law. But there are also mechanisms that I've shared with you. Among them, the authorizations granted under ministerial directives and by judges in some cases. And once again, for 30 years now, and I'm telling you that the roadmap for the Intelligence Service is outlined in the annual reports of the last 30 years of the Oversight Committee, which is able to intervene in various sectors. And this morning you're giving me the opportunity to remind you that C-51 increases, I say, the powers of the Oversight Committee and gives it the specific mandate of reviewing the activities tied in with the reduction of the threat after the fact. But is there something that gives more powers to the Oversight Committee, the Civilian Oversight Committee? Yes, the warrants to reduce threats, and as we've seen in another area, it doesn't pertain to the Oversight Committee, but I'm speaking here more of preventive arrests under warrants. So yes, there are additional tools that allow me to remind you that we are the only country, to my knowledge, and we've looked at what's being done in a lot of allied countries. You must know that we're behind. All of the other intelligence services of our allies are reducing threats. They can intervene. And remember the first question you put to me, can we do prevention of radicalization? Well, at present, the intelligence services that are at the forefront where there is radicalization at play cannot intervene to reduce the threat. So to be consistent with our discourse aimed at reducing radicalization, we must be in favor of the threat reduction measures. And I would repeat that we're the only country with judicial oversight with a warrant granted by a judge. And in the case of these warrants, all of the activities must be described by the service before the judge, and the judge is able to amend, to refuse, to accept the warrant, or to call upon a third party to get critical advice. So that's the system that we have, and we are reinforcing it with Bill C-51. At present, at the committee, there are gaps. There are free positions that haven't been filled. Are you going to be appointing people quickly? When are you going to fill all of the positions available? Is it going to be done immediately? Well, very quickly, yes. There are already close to 20 people who are full-time employees. There are 4 commissioners, and there's a 5th position to be filled. We have to ensure, for example, that we have people, the last person who was appointed, Mr. Holloway, the Dean of a law faculty, we want to have experts. As Minister McKay was saying, it's important to give these mandates to people who have the qualifications, and this is what the staff of the committee is doing.
Mr. Falk, please, 5 minutes.
Mr. Chair, and I want to thank the ministers this morning with their officials for attending this meeting and for your input here. You know, back in the 1920s, my grandparents were experiencing terrorism, what was then known as the Soviet Union, and were refugees here to Canada during that time. And we've been thankful ever since that the government allowed my grandparents to immigrate here under the refugee program. And so one of the things that is of interest to me is of course, the changes being made to the Immigration and Refugee Protection Act. And I'm just wondering, some of the amendments that this bill proposes, if you could clarify as to why they're needed and why those changes are being made.
Yes, sure. Thank you. Well, first, yes, Canada is a welcoming country. Canada is welcoming immigrants around the world every year. More than 200,000 immigrants, new Canadians, are coming here. And they come and they have, certainly, they have, they like, if I can put it that way, our Canadian way of living. So did my grand-ancestor. They were from an Irish. We were... That's probably why I'm so skinny, you know. There were not much money to eat at that time. So to get back to your question regarding the Immigration and the Refugee Protection Act. Well, this is a response actually to the Supreme Court. We just want to make sure that in the case of some individual who could come here and potentially represent a threat to our security, we want to really clarify the rules under which we are able to protect Canadians while ensuring the respect of their right. That's why we've well defined the way in which the information can be processed and also how we can protect national security in that regard. And also there is a clearly defined appeal process for any individual. So once again, this is to clarify, I would say, the procedure under which Canada, when an individual could represent a threat, is dealing with that issue. And we've considered some former decision of the Supreme Court who has indicated that we needed to clarify our law, and this is why this section is in the bill.
I would only add, Mr. Falk, that this ties in with what Mr. Blaney has outlined earlier in terms of the importance of the information sharing that goes on between government departments. And I think it would actually shock some Canadians to know that this isn't already happening to the extent that's necessary in this very fluid and evolving threat assessment. The information sharing is extremely important, particularly with a department such as immigration. And you know, to your very real experience in terms of your family lineage, so many people do come to this country to get out from under the yoke of terrorism, to leave that behind and to come to Canada and avail themselves of the protections that we enjoy in this country. Our charter, our constitution, our way of life is something that they're quick to embrace. And in talking about this bill, I think it's new Canadians, perhaps, that have the greatest perspective on what makes this country great and why they're here and why they're so quick to embrace and participate in the freedoms that we're so fortunate to enjoy. This bill is about enhancing and protecting those freedoms and all Canadians.
Thank you, Ministers, and that's the way I see it as well, that this bill is a step forward in protecting our rights and freedoms. Can you explain briefly what the process is in respect to appealing a decision by the judge during the course of proceedings? Yes, with the security certificate regime.
Yeah.
Well, I would suggest you can go to the section 52 of the bill, which clearly define the technical way in which an appeal can be targeted, and that's really in the bill is describing how it works. Basically, we base our appeal process on other appeal process so that it would be meet constitutional right, and that's how it is feel. I would say it is a model of appeal that compares to those others in other similar situations.
Thank you, Minister.
Minister, and now we will go for...
Mr. Chair?
Yes, yes.
I'd like the discretion of the committee to be allowed to ask a question. As you know, a number of us as members of Parliament requested to share a chair.
Well, no, you don't have the floor. You don't have the floor. I'm sorry. What I will do, the chair will put your request, and if I have a majority decision here to allow that to happen, that could take place. Do I have unanimous support? Yes. No, we don't. Please go on now, Mr. Norlock.
Thank you very much, Mr. Chair, and through you to the witnesses that I'm about to ask questions. Because I have several areas I'd like to hit upon, if they could be succinct, unless they feel it necessary to expand. So my first question will be to Mr. Coulombe, head of CSIS. Mr. Coulombe, in the 30-year history of CSIS, how many times has CERCS chastised or found your organization to be in breach of the rules under which you operate?
From memory, I wouldn't do justice. In all of their, and prior to that, the certification of the director's annual report to the minister was done by the Inspector General for 2-3 years. Now it's done by CERC. Again, from memory, in all of those annual reports, the certification was always that our activities were done in conformity with the CSIS Act, ministerial direction, and it was never an abusive or excessive use of our powers.
So can I take it from that that's zero?
There's been criticism and recommendation on ways to improve the way we do things, but not in terms of breaking the laws. Yeah.
Thank you very much. Also, we heard mentioned by some of the witnesses or some of the questioning, Judge Mosley had some concerns with regard to the activities of CSIS. What have you done, sir, to address those concerns?
Back in the fall of 2013, when the decision came down, the first thing we did, we stopped doing the activities that was caught in that process. But it is very difficult for me to talk about some of the issues because there's still questions that are now in front of the Supreme Court, and it would be improper for me to comment on
Thank you. Thank you very much.
If I may,
yes,
if I may, Mr. Norlock. Yeah. Well, as you know, I came in front of this committee to fix and respond to the invitation of the Supreme Court, which is to define clearly that CSIS has the mandate to operate here and abroad, to exchange information, to protect, to include a witness protection program, and also to protect the confidentiality of the member of the CSIS operating. So this bill is now in front of Senate, and Senate is moving forward, and I am confident that this bill that is simply maintaining the existing capability of CSIS will be approved.
Thank you very much. We heard some of the questions with regard to, of course, the opposition, a lot of process and et cetera, but no real questions concerning the law. And my next question would be concerning real-time oversight. As far as I'm concerned, being in the law enforcement community, real-time oversight means somebody standing over you watching what you're doing. So Commissioner Polson, do you have real-time oversight over you, somebody following you around, making sure that every move your members make is being verified by some other agency?
Seems like it sometimes.
Yes. I'm asking you, are you aware of any police force in Canada that has real-time oversight?
No, other than the internal processes that we have for supervision and leadership within the organization.
It's internal. Thank you very much. I would just like to go back to my friends in CSIS. So you were very clear that serious breaches in the 30-year history where you were criticized by, Madame Blonzy mentioned some of the criticisms by some of the very people who are criticizing this legislation, saying that we're in a police state. So going back to the activities of members of CSIS, I would ask you, do you feel that you have, your members have the oversight that is appropriate to their duties?
I've testified a number of times that, in my opinion, SERC is a robust review mechanism that has proven over the 30 years its value, its impartiality. And I've said publicly again a number of times that our organization is a better organization because of the work of SERC.
Thank you very much. And your members, when they are in their training and are told what their duties are, they are specifically guided by the Charter of Rights and Freedoms, how far they can go with regard to the authority given to them. Would I be correct in saying that that is part and parcel of their training and a major part of it?
It is part of the training. It goes from the Charter, it flows into the CSIS Act, Ministerial Directive, and then Operational Internal Policy. They're all linked.
Fine. Thank you very much, Mr. Norlick. Thank you, Mr. Blum. And now, Mr. Garrison, please.
Thank you very much, Mr. Chair. Mr. Norlick opened up an interesting line of questioning I'd like to continue with when he talked about the RCMP and its internal monitoring of its activities. We used to have an Inspector General of CSIS who did internal monitoring of observance of the law and CSIS activities. And that was eliminated by this government in 2012. So I'd like to ask the Minister, given the broad expansion of powers and activities contemplated for CSIS in this, why not bring back the Inspector General's position? Because the former Inspector General said quite clearly, she actually used the word ridiculous. She said it was ridiculous to think the review committee known as CERC could do the same job of probing the Canadian Security Intelligence Service. She said, quote, they don't do the same kind of work at all. They don't go into the same depth, the same detail. They're basically part-time people. So instead of passing these powers to CERC, which has had the same, basically a flat budget for the last 10 years, why not bring back the Inspector General to help provide that internal oversight?
Well, I thank you for your question, and you are right in saying that there were some concern when the office of the Inspector General was closed, that it could have an impact. Well, it's the opposite that took place, and for this I would refer you to the last annual report of CERC, which clearly says that as required under the CSIS Act, now CERC's interaction with the minister not only have become more frequent, but far from compromising its independence, the relationship has substantially added to the Security and Intelligence Review Committee's role in the system of accountability, and has, if anything, deepened CERC's ability to reassure Parliament and Canadians regarding the activities of the service. So now that this action has been taken 2 years ago, we can say that who has benefited the whole Canadian society and the protection of their rights and their freedoms. And let me just also add this morning that not only CERC can review into all CSIS activities, but it is also possible by the Auditor General and the Privacy Commissioner.
Well, you raised two interesting points there. One, the last annual report of CERC said very clearly that it had problems in receiving complete information in a timely manner from CSIS. So they themselves have said we've had problems doing the oversight because of a failure of cooperation in a complete and timely manner. So how does that square with your argument that this is an improvement in robust oversight?
Well, I'm glad to see you are coming to support our great Security Intelligence Review Committee. Let me just say that Canada is one of the first democratic governments anywhere in the world to establish a statutory framework for its security service. We are pioneer in a totally independent institution That is it critical sometimes at the work of CSIS? Absolutely. Well, actually, you just have to review their report. And indeed, they've done many reviews on counterintelligence investigation, sensitive CSIS activity, namely the carrying of firearm. It's in the report, use of an emergency area of emergency. And they also have a complaint, as you know, process. So we really have a robust system. But what is also important is every year they are delivering a certificate to myself. And the question is, does CSIS operate under the Canadian law? And in most of its reviews, CERC was satisfied this year with the manner in which CSIS carried out its mandate to investigate threats to the security of Canada. And they came up that they came up to give this certificate of approval. So, are they having good recommendation? Yes. Are they making CSIS a better security intelligence? Yes, they are. And in Bill C-51, for which I'm seeking the support of this committee, there are provisions that will mandate CERC to review the threat diminishment activity that are in the provision. So we are increasing the mandate of CERC by the same way.
So very briefly at the end, you mentioned the Privacy Commissioner, who unfortunately is not going to appear before this committee. So my question to you is, did you have a review of this legislation from the Privacy Commissioner before you introduced this legislation? And what do you make of his concerns that this bill involves a significant loss of privacy rights?
Okay, well, yes, we consulted with the Privacy Commissioner, and I intend to meet with the Privacy Commissioner. And as you know, this bill is about the protection of rights and freedom of Canadians and their privacy, and there are embedded mechanisms in Bill C-51 and already within government, such as the privacy impact assessment that will apply to the measures planned in this bill. Thank you.
Thank you, Minister. Now, Ms. James.
Thank you, Mr. Chair. I find it interesting that we keep talking about the Privacy Commissioner not being invited to committee, but in fact, the NDP did not even put that on their witness list. So I just wanted to, well, we all put forward witnesses, Mr. Chair, and that was not one of them put forward by the opposition. But anyways, back to questioning. Minister Blaney, I just want to go back to the information sharing portion of this bill, which is Section 1. There's been some misconceptions with regards to the information sharing, which is actually Section 1 of this bill, and kind of conflating it with the CSIS Act or the amendments to the CSIS Act under this bill with regards to information sharing. The information sharing section does not equate to arrest or prosecution under any sort of terrorism charges. So I just wanted to make that very clear for the committee members here today. And it also, in respect to the ability to share information, it has to fall under the umbrella of undermining the sovereignty, security, territorial integrity of Canada, or the lives of security of the people of Canada. So taking this into consideration, there's been a whole lot of concern about, protesters out there, demonstrations that somehow will be falling under the umbrella of now information sharing aspects of this bill, which is not the case. So I just want to ask you a couple of questions, and if you could just indicate yes or no, whether they would fall under the guise of information sharing as outlined in this bill. Would a peaceful sit-in for any reason have any protesters subject to the information sharing sections of this bill?
Can you repeat your question?
Would a peaceful sit-in, for any reason, have any of the protesters subject to the information sharing portions of this bill?
Well, lawful protest is not included in that bill, and we've seen that although it could be illegal, if it doesn't undermine the security of Canadians, it wouldn't be taken into the Information Sharing Act. So
protesters that might be blocking a road or a railway or even a pipeline from being built, as long as it does not undermine the security and all the other parts that are in this bill, they're not going to be subject to information sharing.
That's it. That's it. And again, it's only existing information that is transferred within the government, the left and the right hand.
But if there was reason to believe that someone was going to bring a pipe bomb or blow up critical infrastructure, that would then fall under the outline of information sharing because it would be a threat to national security. Is that correct?
That is correct. In fact, I would point to some of the language here where While serious interference with or disruption of an essential service or system is part of the definition of terrorist activity, it does not include, to your point about a peaceful sit-in, it does not include lawful or unlawful protest, dissent, or stoppage of work unless there is intention to cause death or serious bodily harm, endanger someone's life, or cause risk to the safety of the public. So, in other words, your description certainly doesn't meet that standard. Nonviolent, unlawful protest is not included in this broader definition of terrorist activity.
Thank you very much. If I could just direct a question to Commissioner Paulson for a moment. We talked about this legislation in response to some of the gaps that were identified by our national security agencies. With respect to information sharing, if you could elaborate on how this would help the RCMP. For example, I think in general terms there are individuals that you may be tracking or you may be monitoring or that may be on that list of 90-odd individuals that you've mentioned before. But then there's other individuals that you may have no knowledge of that may also pose a threat. Could you explain how, first of all, does this legislation in whole or in part fill some of the gaps identified by the RCMP? And with respect to information sharing, how will that be extremely helpful to you?
Well, thank you. Yes, it does fill those gaps, and I think Minister Blaney actually used a couple of examples that are real examples that have happened to us recently in Turkey in terms of an exchange of information from people that were coming out of Syria that had been wounded, and there was questions about privacy implications, from one part of the government exchanging information with another part of the government. So it would be very helpful for those kind of situations. It would also be very helpful in respect of those people that we don't know about. And what we're, I think, proposing is that we begin to shift a culture of a information management culture within the Government of Canada that recognizes those instances where information is plainly relevant and necessary and relevant to the protection of the security of the country, and that it be proactively shared in instances where people recognize that it represents a threat. So very helpful. And I should also say that it's also helpful that some of the measures that Minister McKay was speaking of in respect of the peace bonds and the preventive arrests. Those are things that we identified as being important considerations in this sort of graded application of police powers, because not only does it bring us closer to successful criminal justice interventions, but with respect to the peace bonds, it allows us to intervene in those counter-radicalization initiatives. By having people on conditions, we're able to sort of intervene and work with them to try and get them out of that path.
Fine, thank you very much. And now we will go for around 3 minutes. Mr. Easter.
Thank you, Mr. Chair. Just first on Mr. Norlock's question on Justice Mosley, I have here the court decision, and just to be clear, Justice Mosley found that CSIS breached its duty of candor to the court by not disclosing information that was relevant to the exercise of the jurisdiction by the court. Now, I do expect that CSIS is trying its best to ensure that they follow the rules of the court, and I'll grant them that. But it does make the point, that decision, Mr. Chair, that what the minister claims, a judicial warrant, is oversight. It is not. And let me turn back to oversight for a minute. We're talking to, the minister talks about CERC. We're not talking about oversight just by CERC and of CSIS. Canadians want oversight of all our national security agencies. This bill involves 10 other departments or agencies in terms of the flow of information. So Canadians are basically demanding, and the government, of course, as usual, is not listening, that we want oversight of all these agencies. And I'll turn to, in terms of, I might say too, Mr. Chair, that Mr. Minister McKay tried to put words in my mouth. I do not agree with what he said. And I'll turn to the report of this committee in June of 2009, of which Mr. Norlock was a member, and was chaired by a Conservative chair. They made a recommendation in 2009 for the creation of parliamentary committee to review the activities of national security agencies. They admit in there, Mr. McKay, for your information, that a bill to establish a National Security Committee of Parliamentarians, Bill C-81, was introduced on November 24th, 2005. Who was the government then? It was indeed the Liberals. But that's partisan, and that's beside the point. The fact of the matter is Canadians believe and Canadians need, and we support them. They need national oversight by parliamentarians of all our national security agencies. Will the government consider that and stop playing this game that either judicial or CERC or somebody else does the job? They don't. Will the government consider that?
Well, Mr. Speaker, Mr. Chair, it's very enlightening to hear this now conversion on the road to Damascus from a former Solicitor General who is advocating for something he so roundly rejected when he held the position that Mr. Blaney now occupies. But I'll take him up on his offer to avoid the partisanship. The reality is that with the judicial oversight, with Attorney General consent with regard to recognizance and peace bonds, with the CERC body that we've heard has very robust mechanisms and ability to look into the actions and the activities of our security enforcement, there is oversight. There is also, of course, reporting to Parliament, which this report is now clearly before Canadians through Parliament. The activities, in some cases, have recognizance, for example, come back for sunset review. These are elements in which parliamentarians are very involved, have ability to examine this process that we're taking part in today, as in the time of Mr. Easter, where we had the opportunity to question officials, to hear from experts, to put on the record the concerns that have been expressed, and to have a very open, transparent discussion about what activities this new bill will grant, and examine, of course, in the context, in real time, practical examples and concerns expressed by the Commissioner, by the head of CSIS. That is exactly what is required in this process, so that Canadians can have confidence. This is something Mr. Blaney has underscored many times. Canadians have to have confidence and trust that our security enforcement and security agencies are acting responsibly, acting within the Canadian law, and acting in their best interests. Now, we know that the terrorists do not play by any rules whatsoever. We, on the other hand, are responsible to Parliament, responsible to the courts, and responsible to respond in a way that is within the law of Canada.
Fine. Thank you very much, Minister. And before we as a collective committee thank our witnesses here today, we have in this study an extensive list of witnesses, and the chair needs authority from the committee to pass a budget to support our witnesses coming here. So the chair is making a budget request to the committee of $39,000 for witness expense. Unanimously agreed. Thank you very much. Passed. And at this time, thank you, Minister Blaney, Minister McKay, Commissioner Paulson, and all of our senior departmental officials. Thank you very kindly. Meeting adjourned.